Good evening and welcome. My name is Stan Lozinski, and I'd like to thank you for joining me tonight with regards to our ongoing series of financial planning topics. Tonight, we're going to focus on special needs planning and the basics of this subject. Planning for a personal need and a financial security of a loved one who has a disability or special needs may seem overwhelming, but it doesn't need to be difficult to do this type of planning. And, we're going to focus on some of these topics as we go through this presentation. Again, this presentation, though, is really intended to be a good overview of this topic. At all levels, you should be consulting professionals that can assist you in your planning needs, whether it be an attorney, an accountant, a financial planner, whatever it is, to make sure that you're getting the proper legal, tax, and financial planning advice available with regards to anything on special needs planning. So I'm going to start here sharing my screen, and we're going to get going. So again, talking a little bit about this and the various aspects of special needs planning. Again, keep in mind that is intended only to be an introduction. This is a very complex area of tax and legal aspects related to the care of an individual that has a disability. And again, this is a starting point for you to give you a good overview and educate you a little bit on these areas. Now, let's talk a little bit about the need for this care. Statistically, if you consider the fact that of all of the Americans in the United States, 12.6 of the residents report having some form of a disability. Now, this is going to include, again, 5.4% of persons between the ages of 5 and 15, 6.3% for persons ages 16 to 20, and lastly, about 10.4% of persons ages 21 to 64. So you can see where the need really comes out statistically here. Now, focusing on one of the areas that is more concerning is 1 in 59 American children has some form of autism spectrum disorder. And then you look at the situation with older adults. 1 in 10 basically has some form of Alzheimer's and dementia. So statistically, you see what the needs for this type of planning and how it becomes very important. Just again, as these situations can start as young as birth or later in life due to accident, illness, or again, just aging in that process. So let's talk a little bit about what special needs planning really is. First, it really is the process of providing for the personal and financial security and well-being of a loved one. And, at the end of the day, you really want to make sure that you're focusing on their individual needs, but also yours too. And we'll get into that a little bit as we talk a little further along in the conversation here. Depending on the circumstances for the needs for planning, again, this can be done by the individual by doing some pre-planning with wills and trusts and so on, or again, initiated by someone's loved ones or family members to implement a plan. We're going to talk about that, but let's talk about a little bit of who would, really be the ones that we're looking to protect here. And it would be a child of any age. It could be a sibling. It could be a parent, otherwise a relative or friend. Again, you see where the need here is within the family. And that is really where we see the primary caregivers for these types of situations really stepping up and providing that coordination of care, and the planning process begins there. Now, let's talk about the goals specifically. First of all, as I was mentioning just a second ago, you need to balance your present and future needs with the present and future needs of your loved one that has the disability. And if you think about it, it's very important when you start to conceptualize this. What's happening to that loved one is also happening to you. So you have to be prepared to coordinate your needs and theirs at the same time. And then as you create and implement a plan, you'll meet that loved one's personal needs and goals. And then again, making sure that all of her financial and legal needs are met. The most important aspect of all of this is you have to make sure that you're communicating these plans with the other related parties within the family. You can't go alone on this, and they have to be aware of what the situation is and how it is being taken care of for that individual. I get into this a lot with families when they approach me regarding a loved one that may be going through a disability or an illness that they need to do some planning around. Again, if it wasn't done in advance, we have to make sure that all of the relevant financial and legal documents and again, insurances and so on, which we're going to touch on, are really put in place to make sure the planning process happens. And then again, after you communicate all this, reviewing these plans on a regular basis. We do financial planning in my firm, and as part of the financial plan, we have regular reviews of the plan to make sure that it's on track and meeting the needs of that client. This type of situation, it really falls right into that type of schedule that you would need to be on a regular basis, updating the plan as needed. So, making sure, again, that all the family members of that loved one are all adequately addressed and part of the process. And that's important. Again, you want family harmony, you want unity around and a rallying call around those individuals to make sure that those care needs are being addressed. Now, sadly, there's a lot of times that, they don't plan ahead. And when that happens, we are basically faced with a situation that, certain decisions are going to be made without you. And, that could be involving, if there is no one available at the family level that will step up, the courts will actually go in and appoint a guardian or a conservator for that individual with a disability or an extreme illness. So just be aware of that. Again, the state will determine how much money your estate will transfer to any loved ones that, again, after you pass away and things along those lines. So again, not putting in the proper planning in the front end by having a will or something along those lines will affect the amount that is inherited likely by your loved ones as part of your estate transfer. So that's very important. Money may run out. Again, these are court-appointed people. If there's a guardianship or conservator, they're not so concerned about, every dollar that's being spent for care or monitoring the process. So your money and assets, if things aren't planned in advance, may run out. And that's a concern. We're all concerned about outliving our money in retirement. So again, starting with the basic steps here to get you on the path, you want to implement and create and implement that plan for that loved one. So again, focusing on all of those various aspects of it. Create a transition plan for continued personal care. So again, if situations change, you need to make sure that there is successor plans and individuals that can step in to fill your shoes if you are the primary caregiver or the coordinator of care. Create and execute the legal plan. Again, the need for an attorney in these types of situations is paramount. So absolutely make sure that you get good legal counsel that specializes in estate or special needs planning. Do not go to a general practitioner because they typically are not up to speed with all of the various requirements for filing for example, Medicaid or Social Security income and things along those lines. So very important with regards to all of that. And then lastly is create and implement a financial plan. So let's touch on these. So the first aspect of, create and implement that personal care plan. And who are the primary caregivers, obviously. You, if you are the individual planning for someone else, or other family members or friends. Again, make sure that you are informing everyone of their roles if they are volunteering for this position. If not, again, then you may have to hire some full or part-time professional help to supplement. Now, one of the biggest areas that is the challenge for loved ones, especially if they are the primary caregivers, is what they call caregiver burnout, and it happens. And I see it when I've had clients in the past talking to the spouse of that individual. They're there 24/7, taking care of this individual, whoever they may be. It's a spouse or a loved one. Point is they need a break once in a while. And that's where having full or part-time help come in. And sometimes there is also community-based care that someone can step in and give you the day off, so to speak. So, always keep that in mind that, as primary caregivers, make sure that you do have accommodations for having a full or part-time professional come in and step in your shoes for that day or two, just to give you a break and so you don't burn out. And again, the other aspect to the personal care is where will that loved one live? We all like to think that, care can start in the home. And a matter of fact, when, 4 out of 5 individuals that require some form of assistance, whether it's due to a disability or illness, generally starts in a home care setting as we get older. But again, as things move on, they may require more monitoring and so on. And, again, may need the assistance of a family member or friend. The next level would be assisted living type arrangements. Now, this can encompass a basic assisted living community that provides some custodial care, or it could go all the way up to a skilled care facility. So again, understanding the differences and what the need will ultimately be is important here. Now, step 1 in the plan is, what kind of care is generally needed. If someone is going to be living at home and being in that environment, obviously household chores and daily tasks are very important. Washing and clothing themselves, preparing meals, transportation if they have to go to and from a doctor's office and so on, coordinating doctor's appointments, and also having a safety and emergency plan available. Again, should certain situations arise, who to call in the event of an emergency, things along those lines. And again, now is really where we start to talk about the transition of care. If, have a plan in place, if that individual is not able to provide that primary caregiver status, again, have the ability to call on professional help. Continuity of care is extremely important in this situation. So someone needs to be monitoring, if you do have third parties involved, how the care is to be provided and so on to that loved one. Again, alternating people or services as you need to supplement the plan, but really anticipating the future life events. Will this situation progress to get worse? Starting again in a home setting, will it progress to assisted living or skilled care? Again, understand what the situation you're in and how it will potentially progress for you. And then again, answering those what if questions. What if you passed away unexpectedly? Who is going to step in those shoes to provide that care and coordination? And what if the loved one is not able to make their own financial decisions? So again, knowing how to address those aspects of the plan is extremely important. Now, once you have the plan created, now it's really creating and executing that legal plan, which really is the most important. Medical directives. This is probably the most important document that an individual would have if related to a disability. This is generally a healthcare proxy or a living will. Some states combine the documents, some have it separate. So again, depending on what state you live in, that would be the documents that you would provide. But generally, when people go over state lines, if you're traveling or something like that, or maybe you do, snowbird routine where you go down to Florida for the winters, generally different states will acknowledge the documents from other states. It's reciprocity. Can't get that word out today. Anyway, in addition to the living wills and healthcare proxy, durable power of attorney. Now, this is a general power of attorney. There's several structures to this that you can talk with an attorney about. A durable power of attorney generally means that you're giving to some third-party individual who you trust, maybe it's a family member, whoever, or a close friend, the ability to act on your behalf for legal matters, whether it comes to finance, doing banking, things along those lines. Now, again, you can issue that document right away, even though you may not be disabled yet. Again, this is part of the pre-planning process. Or you can also have what they call springing powers of attorney. A springing powers of attorney generally will take effect once that individual becomes disabled. So in the event of a disability, that document now becomes active and that individual is empowered to act on your behalf in financial matters. The most important documents ultimately at the end of the day is going to be also your last will and testament. Again, your last wishes and so on how assets would be distributed and so on. But in addition to that, if someone has personal belongings in the home that they want to go to specific individuals, generally some people would leave behind a letter of intent or instructions. These are not legally binding, but if you have a will in place, generally you have appointed an executor in that will that is going to transfer the assets out of the estate based on the probate process and so on, or if you have trusts in place, again, according to what the trust is dictating as who the beneficiaries are and how the assets get distributed at that point. But the letter of intent is, hey, I had this special vase or a piece of jewelry that I want to go specifically to this person, or things along those lines. But again, at the end of the day, none of this works unless you have an attorney to work with. So again, going with an experienced attorney that focuses on estate planning or special needs planning is paramount here. I can't tell you how many times I've been called into meetings where the client hires an attorney that is a general practitioner or is a friend and things like that. And I sit there and I listen to how the meeting is going, and I know that they're not addressing all of the aspects of this type of planning that are necessary. So again, go with a specialist. If you had a heart issue, you would go to a cardiologist, not your general practitioner. So in this case, hire an attorney and get one that is an estate planning or special needs attorney. Now, after you're creating the plan and so on, now you really get into the financial planning aspect of this. And this becomes a little bit involved with budgeting and so on. We want to estimate the amount of costs are going to be related to the care of that loved one. You want to project those costs over your loved one's life expectancy. And then also factoring in inflation. Again, all of these are part of an expense program that you really need to keep track of. And it's extremely important if you are going to be applying for any of the government benefits and so on. So understanding the individual's income and what their cost of living and care expenses are going to be is extremely important. And then seeing how long those assets will last based on the expenses that are associated with providing the various levels of care that may be necessary. Now, the next step is really talking about insurance. And insurance is probably the first area that would provide any support for various health, disability, or long-term care benefits related to an individual's illness or injury or disability. Now, this is the first area that's really going to start paying benefits. But generally, insurance benefits can be a little limited. If someone passes away, obviously having life insurance in place would be important to provide liquidity to the estate and also provide supplemental income to surviving spouses or family members that may need that money and so on to continue their life. And again, your legacy is really going to be dictated by the assets that you're leaving behind. And that's where having a will and testament in place is extremely important. And that the assets clearly have beneficiary designations. I can't tell you how many times I've come across individuals that have, 3 kids, they're in their 40s, working professionals, and they don't have a will. They don't have beneficiary designations listed on their retirement accounts, things along those lines. Very important. I've seen what happens when you don't have these documents in place. The estate, as we were talking about earlier, gets diminished because the court will appoint specific individuals as guardians or conservators, or even as executors and trustees to preserve the estate assets while the state determines where the assets are transferred. So again, having those legal documents is extremely important. Now, The reason why we go through the prior steps is, again, to try and ultimately, if someone does have a long-term care need, to qualify for some form of government benefits. Now, some of these are needs-based, based on your household income and so on, or assets that that individual hold. You may have to legally protect some of the assets that you currently maintain for your beneficiaries to make sure that these assets are protected and that you would qualify for any of the public assistance that you may be ready to qualify for. Now, the sources of benefits, again, there could be national organizations, some associations will provide benefits to individuals that have certain care needs. Then you have community aid. This could be community-based Medicaid or hospice care, state aid, again, and then also federal. And these can be combinations of various aspects of Medicare, Medicaid, Social Security, disability income, SSI income. So we're going to talk a little bit about each of these. Now, Medicare is probably the most familiar aspect of retirement medical insurance that an individual will get through Social Security. You qualify for this at age 65. Generally, it is hospital, doctor, and prescription coverage that you would maintain. And these benefits, though, generally for individuals that are disabled, can be rather limiting when it comes to any sort of skilled care. So again, understanding these benefits that you're eligible for, you don't have to be age 65 to be on Medicare. If you are disabled or at end-stage renal failure disease, you would also qualify for that. Now, the next level will be Social Security disability income. This basically is income that is provided to you, accelerating your Social Security benefits for disabled workers. It could be a widow, it could be children of a deceased. Again, these are people that would be eligible to start receiving these benefits. Next, you would see potentially now the federal needs-based programs. Now, this is where the Medicaid planning really comes into effect. These are programs that were based primarily on an individual's income and assets. So it is so important when you start looking at the planning that we are going to be talking about, the special needs trusts and so on, that you understand that those types of trusts are designed to protect the assets that you currently have so you can qualify for these types of benefits with Medicaid and so on. Now, there's also what they call supplemental Social Security income. Now, this is for, people that are over age 65 who are blind or disabled, again, limited income or financial resources. Now, certain special planning techniques related to this, again, these were permitted under state and federal law to maximize available resources for that individual when they became disabled. And with the proper planning, the government benefits may be available to the family as additional resources. So it's very important to understand that. And again, once these benefits are maximized, though, the family may need to also utilize some of their personal savings for providing for additional expenses and so on. And then again, their personal or secondary source of support, again, through the family. And these are some of the realities that we see out there when it comes to planning. So the first type of trust here that we're going to talk about, a special or supplemental needs trust. These are basically considered available when assets need to be protected and you're involved in a means-based type public assistance like Medicaid or Social Security income. Again, it's important to understand these trusts and what they would provide. These basically were given, protected status officially back in 1993, with the idea that, over certain time periods, these assets would accrue protection so they wouldn't be clawed back if you did qualify for Medicaid and so on. And then talking about additional income and so on, when the assets are protected, they will not be counted towards qualifying for Medicaid, in addition to some of the income needs for that individual, as disbursements are generally paid out over time. So again, understanding, as we talked about earlier, about what income sources that individual has, what assets do they have, what expenses are they going to be incurring. This is where all of it starts to become very relevant, and why you need to keep track of all of the expenses for that individual. Whether it's, making the real estate tax payment, or paying for, oil and gas and so on for the household, electric, whatever it may be. And then on top of that, all of their medical expenses and so on. Again, being organized and having this financial plan in place, knowing the cash flow and expenses over time, is extremely important. So, and again, when it comes to the legal planning with these types of trusts, that's when things really start to come together. Now, there's a few types of special needs trusts that you have to understand. One is called a self-settling or first-party special needs trust. Then there's a pooled special needs trust or a third-party special needs trust. And there's costs and expenses associated with each types of these trusts. So it's, again, when you sit with an attorney, understand what these items involve. First-party or self-settled trust are basically a trust created for the sole benefit of an individual with a disability who is under age 65 at the time of the trust creation. And the trust must be created by the individual's parents, grandparents, or legal guardian or court, or by the individual with a disability with capacity, meaning that they're able to make decisions on their own. The trust is funded with assets from the individual with the disability. For example, the trust could be funded with money they have inherited or received in a settlemental lawsuit, or as the result of a divorce, things along those lines. So again, how does someone benefit from a self-settled trust? Well, we've already talked about how you qualify for Medicaid and also the potential for look-back periods and so on. So again, having this trust in place, and there is these timelines. Typically, it's around a 5-year look-back period, depending on the size of the assets that were placed in the trust. So again, understanding those little Medicaid look-back provisions are extremely important. Again, assets in the trust will not be countable as a resource for eligibility purposes with their benefits under Medicaid. And upon an individual's death, any money in the assets remaining in the trust must be used to reimburse the government for their medical benefits extended during his or her lifetime. So again, there's a purpose behind these types of trusts, and again, how the assets are protected while this goes on with regards to their care needs. Now, talking about a pooled trust, generally a pooled trust is managed by a not-for-profit. We hear some of these sometimes. You'll hear certain religious groups or something like that that have their charitable trusts and things along those lines. And basically, they're a separate account that's maintained for each beneficiary. Sometimes they will still provide income. So again, understanding what kind of these pooled trusts are available. And again, it works similarly to the self-settled or the first-party trust, again, protecting it from Medicaid and so on. Any assets that remain in the account, again, upon the individual's death, can be used to pay back Medicaid, or they can remain in the trust to help others, depending on the state laws. So again, understanding these types of trusts that are available to you based on your state is extremely important. Now, the third-party trust basically is created by the parent of an individual with a disability or another third party. We had talked about if someone was appointed by a court or something along those lines. But this type of trust has no payback requirement. The person establishing the trust must not have the duty to support the individual. So the individual must be age 21 or older, depending on your state laws. There's no requirement that the beneficiary with the disability be under age 65. So again, over 21, and it can be up to whatever age. And again, just understanding that the transfers in this type of trust, if it's not drafted correctly, it can sometimes trigger ineligibility for Medicaid and Social Security income benefits. So again, having an attorney that knows what they're doing is extremely important in this situation. Now, another type of trust that is available out there is what they call an ABLE account. Again, this is similar to the 529 college savings programs. It can be opened by or on behalf of the individual with significant disability on or before age 26. The individual, though, must be eligible for Social Security disability income or supplemental Social Security benefits. Again, it could be based on blindness or disability, or again, disability certification from a physician. So again, having this type of trust in place is important. And again, you'll still be able to qualify for public assistance with this type of an account. So again, Medicaid, Social Security income, things along those lines would still be available for a person. It basically allows them to address the issue of being able to continue to save money without disqualifying them for the medical support that they're getting or care support under Medicaid or supplemental income benefits. Now, these types of accounts are generally tax advantaged, again, tax deferring or tax-free distributions, depending on what the usage is. Again, they're available to individuals with disabilities before age 26. And again, the accounts are funded generally would not count towards the personal asset limits under Social Security income or Medicaid. So again, understanding those aspects of this is extremely important. They're operated in generally by the states, similar to the 529 plans. Again, understand which one is available within your state is extremely important. Eligible individuals may have only one account, so you can't open up multiple accounts to meet the rules under this particular situation or take advantage of the benefit. Again, after-tax contributions can be made into the account by anyone, and the earnings are tax deferred, distributions are tax-free, and again, they can be used to pay for qualifying disability care expenses. So very important to understand that. And again, the annual contribution limits by the federal gift tax, you can go up to 15,000, but again, you may, depending on the situation, may be able to contribute more. And there is, though, a lifetime contribution limit to these plans, similar to what 529 accounts do have also. So depending on the plan and the state that you're in, just make sure you understand those aspects of it. You do not, though, with the ABLE accounts get the federal tax deduction, but the states may offer some tax deductions or other types of benefits. The owners can contribute to their own account. They may be eligible to claim a saver's credit. So important to understand that. Again, when I mentioned earlier about working with your professionals, your accountant that handles the filings from the tax aspect of the plan that you put in place are going to want to be involved with this and understand what those tax benefits would potentially be. And again, funds from the 529 college accounts can be rolled over into the ABLE accounts if certain requirements are met. So again, understanding what your state makes available to you, and again, how they're administered for the benefit of that disabled individual is important. Now, the funds may be subject to Medicaid payback provisions in the event of the beneficiary's death. So the individual with the disability may be obligated with the ABLE account to transfer that money back to Medicaid for the purposes of paying back their care, for their care, if there is a balance left over in the account at death. And then again, both the Special Needs Trust and the ABLE accounts are, or could be the appropriate tool. Again, consult with an attorney on this. It's very important. Let's talk about, concluding the basic aspects of this, taking a moment here, if you do have a loved one who has a disability or who has a special need, you're definitely concerned about their future and their needs. And that's 1,000% understandable. But again, you make sure that you are understanding all of their needs, go through the planning process, and make sure that you are on the right footing here, organized, keeping track of expenses, and so on. Are you concerned about your loved ones meeting, both their needs and your own? Remember, as I mentioned earlier, caregivers burnout is real, and you may have certain financial requirements that you need to address throughout your lifetime. So caring for an individual you have to make sure that you are part of that plan. You know, it can't be all for that individual. You as a caregiver have personal needs also. You have financial, emotional, and, you know, again, your own medical needs that have to be addressed. Don't ignore them. This is all part of the plan. Get the help that you need if that person does have a disability or is home ill. Hire a full or part-time assistant, aide, whatever it is, nurse, to make sure that they can step in and give you a little bit of peace and quiet, or maybe just that day off that you may need to just gather your thoughts and, you know, make sure that you're addressing your own personal situation as importantly as theirs. I'd like to thank everyone for their time. This is a hard topic sometimes within families, and especially when you're talking about preparing wills, trusts, and so on, and you do have an individual that does have care needs. I like to encourage people to really try and do a same page meeting within a family. Get everyone together, have a very open and frank conversation about who is going to be providing care to that individual, where is the money going to come from, what kind of planning is going to be needed, and who might potentially step up to help. And again, if there is not a lot of support in that area, make sure that you have some reliable backups with regards to a full or part-time aide or visiting nurse, whatever it may be. Contact those associations, whether it's an Alzheimer's association, if that's the situation, or an autism organization. They can sometimes provide assistance to the caregivers for the benefit of that individual that they're taking care of. So again, look at all your resources and make sure that you do the planning. Get a qualified estate or special needs attorney, and also make sure that everybody is familiar with every aspect of the plan that you are putting together. That will lead to all the great success. Again, I want to thank everyone for their time tonight. I really, truly appreciate it. And I wish you all a wonderful evening, and God bless. Take care.